This advice comes from Laurie Hart, attorney with the law firm of Collister, Nebaker, and McCullough. The term probate means to prove and is used to describe the legal process of settling the estate of a person who has passed away. This process involves identifying the decedent's probate assets, paying the decedent's debts, and distributing the remaining assets to those entitled to receive them. Probate is necessary to transfer title to the beneficiaries of the estate if a decedent owns assets titled solely in his or her name. Generally, when someone dies, only a personal representative or executor has authority to deal with the decedent's solely owned assets. Under Utah and Idaho law, assets worth up to $100,000 can be collected by the rightful beneficiaries using a simple affidavit. There are many assets that pass outside of probate because of how they are titled or because they have a designated beneficiary. Examples include jointly owned assets that pass to the surviving joint tenant, payable on death accounts, transfer on death accounts, insurance proceeds payable to the named beneficiaries, death benefits under retirement accounts, and assets held in a trust. There are times when it is advisable to do a probate. If the decedent is a professional who may have a professional liability claim asserted years after their death, a probate can be used to cut off any unknown or future creditor's claims. A probate is helpful if there is a dispute between heirs, concerns about the validity of a will, or where certain estate tax elections can only be made by a personal representative. The probate process, in most cases, is relatively simple, and in the hands of a knowledgeable probate attorney, need not be expensive. A large number of estates don't need to be probated. Be leery of someone selling expensive estate plans just to avoid probate. They are preying on your fears and misunderstanding of the probate process in order to sell you products that are overpriced and not necessarily what you need.